What do you do? I'm a civil rights attorney. Well, today, you're a suspect.
It was a Saturday afternoon in Alexandria, Virginia, the kind of afternoon that feels almost deliberately peaceful. Families stretched across blankets, children chasing each other near the river, the smell of cut grass and funnel cake drifting through the warm June air. And on a park bench, a man sat with his legs crossed and his phone in his pocket, watching his two children play on a playground 30 feet away. That man was Elias Sterling, and in less than 11 minutes, Officer Brett Halloway would make the single most catastrophic mistake of his professional life. Not because he didn't know who Elias Sterling was, but precisely because he didn't. What Officer Halloway didn't know was that in the next 9 minutes, his routine park sweep would transform into a federal incident that would cost the city of Alexandria $10 million, end his career in law enforcement permanently, and eventually send him to a federal correctional facility for 7 years. But to understand what happened at Founders Park that afternoon, you first have to understand who was sitting on that bench. Elias Jerome Sterling was born in South Philadelphia in 1979. The second child of a woman who worked 2 jobs and still couldn't keep the lights on every month. By the time Elias was 7, he was in the foster care system. Not because his mother didn't love him, but because the system, as it so often does, confused poverty with neglect. He moved through 4 different homes before he was 13. He learned early that the people with the clipboards, the badges, and the authority made decisions that determined your entire life, and that most of them never had to explain themselves to anyone. That realization didn't break Elias Sterling, it focused him. He read everything he could get his hands on. His foster parents in West Philadelphia, a retired school teacher named Dorothy Crane and her husband Harold, recognized something extraordinary in the boy and pushed him toward academic competition programs. At 15, Elias was winning regional debate championships. At 17, he received a full scholarship to the University of Pennsylvania. He graduated magna cum laude with a degree in political science and a minor in African American studies. And then, defying every statistical probability stacked against a kid who aged out of the foster care system, he was accepted to Yale Law School. At Yale, Sterling didn't just study the law, he dissected it. He understood, at a molecular level, how statutes were written to protect institutions from accountability, how procedural rules could be weaponized against plaintiffs with fewer resources, and how the gap between what the Constitution promised and what American courts delivered was often a chasm you could lose entire generations inside of. He graduated in the top 5% of his class. He clerked for the Third Circuit. He then turned down offers from 3 of the most prestigious litigation firms in the country, and instead opened his own practice in Washington, D.C. at the age of 31. Sterling and Associates became something rare in American civil litigation, a firm with a perfect ideological focus and a devastating win record. Over 14 years, Elias Sterling and his team dismantled 12 municipal police departments through federal lawsuits, forced the dissolution of 2 sheriff's offices facing systemic corruption charges, and authored a legal brief that was cited by the Supreme Court in a landmark 4th Amendment ruling in 2019. Legal scholars at Georgetown called him the most dangerous man in a courtroom that money didn't put there. His peers called him something simpler. They called him the best. He had also, somewhere in the relentless machinery of all of it, become a father. Maya was 10, Leo was 8. Sterling raised them with the kind of intentionality that only someone who grew up without a stable home could summon. He coached Leo's soccer team on Saturdays. He read to Maya every night, even when he had a trial the following morning. He was meticulous about their understanding of the world, not shielding them from its ugliness, but teaching them the tools to navigate it. He told them repeatedly that the law, when properly applied, was the ultimate equalizer. That knowledge was armor, that composure was power. On June 14th, he took them to Founders Park. Founders Park sits along the Potomac River waterfront in Old Town Alexandria, a green open space flanked by historic townhouses and a marina. On weekends, it draws hundreds of families. It is not a place where people expect confrontation. It is, by every observable measure, a sanctuary. Sterling arrived at 1:47 p.m. He found a bench near the playground, sent the kids off to play, and sat down. He was wearing a short-sleeve linen shirt, khaki pants, and loafers. He had his phone in his hand and a cup of coffee from a shop 2 blocks away. He was, by every account of the dozens of witnesses present, doing absolutely nothing. Officer Brett Halloway had been with the Alexandria Police Department for 10 years. His personnel file, which became public record after the incident, was a document that raised serious questions about why he was still employed. Halloway had received 3 formal complaints in 5 years for what Internal Affairs documented as disproportionate response to non-threatening subjects. 2 of those complaints came from individuals he had deployed his taser against. not in violent confrontations, but in situations where, according to the reports, the subjects had failed to comply quickly enough with verbal commands. Halloway had completed the department's standard use of force training, but colleagues would later testify that he spoke often about what he called a warrior mindset, the idea that a police officer's authority must be asserted aggressively and immediately, or it ceases to exist. He was patrolling Founders Park that Saturday under a vague departmental directive called a loitering and public nuisance sweep, a policy that, notably, had no written criteria for what constituted a loitering violation, no specific conduct thresholds, and no supervisory oversight mechanism. It was, in practical terms, a blank check for an officer to approach anyone he considered suspicious and demand compliance. At 1:58 p.m., Halloway approached Elias Sterling. He told Sterling he was in violation of a park ordinance regarding an unleashed dog. Elias Sterling did not own a dog. There was no dog. When Sterling, calmly and without moving from his bench, asked Halloway to provide the specific ordinance number he was being cited under, the exchange shifted. Witnesses would later describe a visible change in Halloway's posture, a tightening of the jaw, a step forward, a hardening of the voice. He repeated the accusation. Sterling repeated the question. This is the moment federal prosecutors would later identify as the constitutional line Halloway crossed, not because of what he did next, but because of why he did it. The escalation that followed was not triggered by a threat. It was not triggered by resistance. It was triggered by a black man in a public park who knew his rights well enough to ask a precise legal question, and an officer who experienced that knowledge as an act of insubordination. Sterling stood up, not aggressively, not suddenly, but calmly, and called toward the playground. "Maya, Leo, come here, baby." He was leaving. He was doing the most reasonable, measured thing a person could do in a situation that had already become unreasonable. He was removing himself and his children from the presence of someone who had just accused him of a violation that did not exist. Halloway drew his X-26 taser. The red laser dot appeared on Elias Sterling's chest. In the daylight, it was visible to everyone within 40 feet, and there were a lot of people within 40 feet. What followed was captured on no fewer than 7 separate devices. Bystander phones, 2 of them recording in 4K resolution, and Halloway's own departmental body cam, which he had not deactivated. The footage shows Sterling standing still, both hands visible at his sides. It shows Maya and Leo running toward their father, because that is what children do when they are frightened and their father is there. It shows Halloway pointing a weapon at a stationary, non-resisting man while his children close the distance between them, screaming. And it captures with complete and devastating clarity Officer Brett Halloway saying, "Get back or I'll fry him in front of you. Face down on the grass, counselor, or you're riding the lightning." He knew the word counselor. Someone had told him, or he had noticed something, or the professional confidence Sterling carried had registered as a signal. It didn't matter. What mattered was that in that moment, Halloway made a choice to threaten a child's father with electrocution in front of that child while the child was running toward him. Maya was 10 years old. Leo was 8, and the man pointing a weapon at their father had just told them, explicitly, in plain language, that he was prepared to hurt him while they watched. There are moments in cases like this where the law and the human experience align so completely that even the most technical legal arguments become almost secondary. This was one of those moments. Sterling did not raise his voice. He did not move toward Halloway. He placed one hand gently in front of his children when they reached him, looked directly at the officer, and said quietly, "Badge number and name, right now." Other bystanders had already called 911. 2 off-duty officers from a neighboring jurisdiction who had been at the park with their own families intervened and de-escalated the situation. Halloway holstered the taser. Sterling collected his children, sat back down on the bench, and began drafting a legal memo on his phone. He already knew exactly what was coming. If you've watched this far, you already understand something that most people in this country never get the chance to see: what accountability actually looks like when the person on the receiving end of the abuse has the knowledge, the resources, and the absolute iron will to fight back. Most people don't. Most people walk away from encounters like this shaken, silenced, and afraid to say anything at all. Elias Sterling is not most people. But the system that allowed Brett Halloway to function the way he functioned for 10 years is the same system that millions of people face every single day without a Yale law degree in their back pocket. If that distinction means something to you, make sure this story reaches someone who needs to hear it. The lawsuit filed by Sterling and Associates against the city of Alexandria and Officer Brett Halloway individually was 47 pages long and represented what legal analysts described as one of the most precisely constructed civil rights complaints filed in the Eastern District of Virginia in a decade. It cited the Fourth Amendment violation, unlawful seizure, and excessive force applied against a non-resisting, compliant individual with no probable cause and no articulated legal predicate. It cited First Amendment retaliation, arguing arguing with video evidence that the escalation was a direct and documented response to Sterling exercising his constitutional right to question the legal basis of his detention, a right established in multiple circuit precedents that Halloway's own department training materials referenced. It cited intentional infliction of emotional distress, specifically for the psychological harm caused to Maya and Leo Sterling, both of whom required trauma-focused therapy in the weeks following the incident. It cited 18 U.S.C. Paragraph 242, deprivation of rights under color of law, for the threat of force applied in the complete absence of any lawful justification, and it addressed something that emerged only after Halloway filed his official incident report. In that report, Halloway wrote that Sterling had clenched his fists and lunged toward the officer in a threatening manner at the moment Halloway drew his taser. That description appeared in the official police record. It became the department's initial public position. It was the foundation upon which the City of Alexandria's communications office issued a statement defending the officer's actions as consistent with established use of force protocols in the face of an escalating threat. The 4K footage from bystander Marcus Webb, who had been recording the encounter from the moment Halloway approached the bench, showed Sterling's hands open at his sides for the entire duration of the confrontation. There was no lunge, there were no clenched fists. The report was not a mischaracterization, it was fabrication, and Halloway had written it on a city-issued computer, submitted it through official departmental channels, and signed his name to it. That single document transformed a civil rights lawsuit into a criminal matter. The City of Alexandria retained outside counsel within 48 hours of the lawsuit filing. That counsel reviewed the evidence over a weekend and issued an internal recommendation that the city settle immediately at whatever number Sterling's team demanded before the case reached discovery. Their reasoning was not complicated. The footage was unambiguous. The fabricated report was indefensible, and Elias Sterling had personally argued the evidentiary standards for police misconduct cases before the Fourth Circuit. The city was not going to win. The only question was how much losing was going to cost. Sterling's team demanded $10 million. The City of Alexandria agreed within 3 weeks. The $10 million settlement, confirmed by the clerk of the Eastern District of Virginia and reported by the Washington Post, the Associated Press, and the National Law Journal, was the largest individual police misconduct settlement in the city's history. The agreement specified that it was structured explicitly as a deterrent penalty, a formal acknowledgement that the conduct was so egregious that a jury award, if the case proceeded to trial, would likely have exceeded it. The city's insurance carrier reportedly refused to cover the full amount, requiring Alexandria to draw from its general fund, a political crisis that accelerated the reforms that followed. Brett Halloway was terminated from the Alexandria Police Department before the settlement was finalized. The Virginia Department of Criminal Justice Services, through the Post Council, initiated a certification review and, following a formal hearing at which Halloway declined to appear, revoked his peace officer certification for life. He will never again work in law enforcement in the Commonwealth of Virginia, and under reciprocity agreements with neighboring states, his revocation is flagged in the National Law Enforcement Database. The Department of Justice Civil Rights Division opened a parallel federal investigation within 30 days of the incident. The fabricated incident report was central to the prosecution. Halloway was indicted on 2 counts, official oppression under Virginia statute, elevated to a federal charge given the civil rights dimension, and felony child endangerment for drawing a weapon in a manner that placed Maya and Leo Sterling in reasonable fear of imminent physical harm to their parent in their direct presence. After a 6-day trial in the Eastern District of Virginia, in which the bystander footage was played in its entirety for the jury, and Marcus Webb testified for 3 hours, Halloway was convicted on both counts. He was sentenced to 7 years in federal prison without the possibility of early release in the first third of his sentence. The institutional consequences extended far beyond one officer and one city budget. Within 8 months of the incident, the Virginia General Assembly passed the Sterling Children's Protection Act, a piece of administrative reform legislation that carries Elias Sterling's name not because he lobbied for it, but because the incident that inspired it had become impossible to legislate around. The act established what is now referred to as the Visual Trauma Protocol. Any officer who displays a weapon, lethal or non-lethal, in the presence of a minor during a nonviolent encounter is subject to an immediate mandatory fitness for duty hearing and automatic administrative suspension pending that review. The protocol removed the internal discretion that had historically allowed departments to investigate themselves and clear their own officers. The review is now conducted by an independent civilian panel. The act also restructured liability insurance requirements for sworn officers in Virginia jurisdictions above a population threshold. Officers are now required to carry individual professional liability insurance, a model borrowed from the medical and legal profession, meaning that the financial exposure for misconduct no longer rests entirely on the public. For an officer with Halloway's disciplinary history, the practical effect of this provision would have been simple. He would have been uninsurable and therefore unhireable years before June 14th. Founders Park itself underwent a security overhaul. The city dissolved the loitering sweep patrol program entirely, replacing it with a community engagement initiative staffed by officers trained specifically in civilian-centric communication and de-escalation methodology. The new program does not use the language of enforcement. It uses the language of presence, of being a recognizable, trusted, non-threatening figure in a shared public space. Elias Sterling gave one public statement after the settlement was confirmed. He delivered it in front of the courthouse with Maya and Leo standing beside him, and he said something that legal journalists quoted for months afterward. He said that he did not bring this case because he needed the money. He brought it because he had spent his entire career telling clients that the law, when properly applied, was the ultimate equalizer, and he refused, on a sunny Saturday in June, in front of his children, with a laser dot on his chest, to let one man with a badge and a broken moral compass make that statement a lie. He said his mother, who had died in 2011 and never saw what he became, used to tell him that the system wasn't built for people like them. He said he had spent 20 years proving her wrong, one courtroom at a time, and then he took his children home. The footage from Founders Park has been viewed more than 40 million times across platforms. Legal scholars use it in classroom instruction. Police reform organizations cite the Sterling Children's Protection Act as a model for state-level administrative reform that bypasses the legislative gridlock that stalls federal action. And somewhere in a federal correctional facility, Brett Halloway is serving the first years of a 7-year sentence for a decision he made in under 60 seconds on a Saturday afternoon because he saw a black man sitting on a bench who wasn't afraid of him. The law, when properly applied, is the ultimate equalizer. Elias Sterling didn't just say that, he proved it in 4K for 40 million people with his children watching.